Good morning. Welcome to a video recording of the recent Join the Dots estate planning talks that I've been giving in the local community over the last few weeks. As promised, this is a video for people that weren't able to attend, or perhaps you did attend, and this is a reminder of the kinds of things, kinds of topics that we were talking about. If you have any questions, the live events were quite interactive. Definitely if you're looking at this on YouTube, leave comments or ask questions below and I'll endeavour to answer them for you. Or if you're watching this from an email or in any other format, don't hesitate to get in touch and we'll look to answer your queries or your questions. So the theme of the event was Join the Dots for estate planning. And the reason being is that we're in a pretty unique perspective really, because we're legal planners as well as financial advisors for people in later life. And when you've got that kind of overriding viewpoint of someone's situation, what we tended to find was that there was a lot of gaps and inconsistencies in people's estate planning. So for example, you might have done a will a few years ago with a solicitor and perhaps got a lasting power of attorney document in the top drawer that you'd taken out a few years ago. You might have a financial advisor who has advised on a pension or some inheritance tax planning. But all of these pieces of advice are inherently, in my experience, transactional and piecemeal, and no one's really got an overview, an overriding view of and perspective of your financial situation. And these are really important decisions that you're making, and the advice needs to be joined up, in my view. So when you're looking at your will or your lasting power of attorney, it's important that that's aligned to your inheritance tax, to your care funding decisions. If we're talking about lasting power of attorney, you know, your thoughts naturally are guided towards care funding decisions perhaps in later life. So I'm Richard from Harold Stevens, I should say, and we organise the business purely with people in retirement and later life in mind. So we see ourselves as the centrepiece, or the later life person as the centrepiece of our advice process. And so our specialism is legal planning and financial planning for people in later life, to give us that overview from a professional advice point of view. But also we've spent years sourcing the very best in class in terms of signposting other professionals and other organisations in this area. So when you come in and see us for an initial chat or meeting, complimentary by the way, there's no cost for that initial chat. More often than not, we can help either in our financial hat on, or we can signpost you towards someone else or some organisation in later life that can help you. So we believe this later life specialism gives us this unique perspective. And so the whole theme really of this talk is estate planning and joining the dots with all different aspects of your situation in later life. So it is an estate planning talk, so there's definitely a bias or a focus on estate planning. So I'll be going through lasting power of attorney, wills, probate, but with a nod to those other professional advice situations like financial planning, care planning, investment, inheritance tax planning. So a fairly ambitious talk in just under an hour to talk about all of those different things, which is why it did generate a lot of questions when I was delivering the talk face to face. But we'll see how we get on. Obviously everyone's situation is completely different, and by far and away the best way of dealing with your own situation is to give us a call and we can have a chat and see if we can help, or pop into the office and see either me or James, and we can have a very relaxed discussion about some of the things that I'm going to bring up today. So hopefully we can help. If not, we can usually signpost you to someone that can help, as I say. So I'll take you through, as I say, lasting power of attorney, wills, and then probate. The majority of the talk is on lasting power of attorney, I would say, which is kind of more in line with lifetime planning, I guess. But we'll cover as much of wills and probate as we can as well, okay? So let's start with lasting power of attorney as the first section of the talk. So I'll take you through the application process for lasting power of attorney from an admin point of view. I'll take you through the advice required around the application process and the importance of taking advice. And then lastly, I'll take you through the steps required for that practical implementation of lasting power of attorney, the important stage where the LPA actually starts getting used by your attorney. So let's start with the application process. It's a common myth that a lasting power of attorney is just a name and address on a form that gets submitted, put in the top drawer, and it's all sorted. I'm afraid that it requires very expensive solicitors to remedy and solve issues around lasting power of attorney at every step of the way. So I can't urge you enough to make sure that everything is done properly from outset. And that comes down to just even down to the admin, the application part of it. So it's a hell of a form to submit to the Office of Public Guardian, and it's so easy to make mistakes when you are applying for your lasting power of attorney. So I've seen everything, dates of birth in the wrong boxes, different witnesses or witnesses that shouldn't be witnessing the document. The big one that I see all the time is the signatures not being in the correct order. So there's a legal process where everybody has to sign the document in the right order. There's just different spelling mistakes, addresses wrong, all these kinds of things. It's just so easy to do on a document of that size. And the reason why that's so important is because there's quite a delay in getting the registration with the Office of Public Guardian through when you submit your document for registration already, even if the document is correct, the application is correct. If there's any problems with the application, it'll come back to you and that can delay matters further. And the problem with all of these delays is at that moment you might need that lasting power of attorney document. You know, it might be a position of stress or crisis. You might need that document to actually start making decisions for the person that can't do so anymore. So strongly recommend that even from an admin point of view, just go through the process. With us, it's actually quite an enjoyable process. You come in, have a cup of tea, piece of cake. We tell you exactly where to sign and where and get everything right. We have a checking service to make sure that even if we're submitting the application, we know that it's going to be a correct document, it's all going to go through correctly. So just from an admin point of view, it's useful to know that it's better to get things right up front. I had a client who was determined to do their lasting power of attorney document themselves, and it took 18 months to get the document registered just because of the toing and froing and the problems and the mistakes, dates getting in the wrong order between them and the Office of Public Guardian. So take advice on the admin side of things. In terms of advice around the actual application, again, unfortunately, it's just not a case that it's a couple of names and addresses, submit it, and then everything's fine. Unfortunately, I would strongly recommend to take advice through the application process to make sure everything is correct from outset. Because, as I said, there are horror stories at every part of the process, most of which can be remedied by getting the actual application right in the first place. So one of the things I should say is the Office of Public Guardian are only looking for obvious mistakes and errors and things being signed in the wrong place when they when they register your document. They are not looking for the legalities, they're not looking to see whether the document is legally enforceable, they're not checking for inconsistencies, all of these kinds of things. They're just looking at purely from an admin point of view. And that can create problems down the line when you actually start to use the document. So again, just making sure that it's all done correctly up front is really important. Lean on our checking service. It saves a lot of time and money down the line. So the first thing perhaps to think about when you're applying for your lasting power of attorney is who the attorneys are actually going to be. Now, one of the perhaps the numbers are mind-bogglingly low in terms of people that have got lasting power of attorney, even for people that are in later life. And it just becomes increasingly important to get lasting power of attorney as you age. You know, you may start encountering issues, start becoming not being able to deal with your affairs in the future. And I'd say the majority of the concerns of the people that don't get lasting power of attorney done is a loss of control over your affairs. Now, what I would say to that would be the biggest way that you can lose control of your affairs is not having lasting power of attorney in place, because what it means is that if you don't have an LPA and you've lost capacity, an application has to be made to the Court of Protection, which can take over a year. It's an expensive, it's an intrusive process, and the court decides basically how your life is going to run going forward and who's going to deal with things. So you basically have zero control over your life, over your goals, over your aims, you have no guidance, you just have no control in that instance. So it's really important that whilst you still are able to communicate your preferences and your goals and what you want to happen, that you address this issue now. And as I said, the first thing to think about is who are going to be those people that are going to carry out your wishes. And these are the attorneys. So choose your attorney wisely. Again, a lot of people will say, oh, it's straightforward, I'll just choose my spouse or perhaps my children. And it might be the case that those people are the people that we put on the document. But there's a lot of lovely people, friends and family out there who have your best interests at heart, who are absolutely awful with money. Equally, there are good people who are great with the finances and money, but you wouldn't want them to be by your bedside looking after you, serving you up medication. So it's really important that we deliberate and think about who these attorneys are actually going to be. Are they, from a financial point of view, are these people able and capable to actually deal with money? You know, do they have the time to do with things? Are they local? Is it going to be practical for them to deal with not only financial matters but also health matters and living arrangements? You know, especially on the health and welfare lasting power of attorney. You know, you're going to need someone that might have to be up in the middle of the night to deal with an emergency and that kind of thing. So, you know, we need to think carefully about who these attorneys are going to be. Not all attorneys get on. You know, finance and health, they're the main reasons why, you know, families fall out, they argue, and we don't want that kind of toxicity within a family at a time of crisis. You want the ability to actually let people know what you want to happen in these instances. So what happens if an attorney's abroad? So, you know, in theory, an attorney can be abroad and still be your attorney, but how practical is that on both the finance and property and the health and welfare? You know, a lot of financial institutions, they look for, you know, people to come into branch, or they're looking for a UK address or a UK telephone number. From a health and welfare point of view, as I said, how practical is it if you're abroad that you can actually help if you've had a fall and you're in hospital and doctors are looking for guidance, or you're looking to make decisions around day-to-day living. So think carefully about appointing attorneys who are abroad. One of the big things is how are decisions actually going to be made. One of the choices that you make during the application stage is whether decisions are going to be made by the attorneys on a jointly basis, on a jointly and severally basis, or for some matters jointly and severally. And it's really important that we have that discussion and you take advice around how these decisions are going to be made when the time comes. So having everything jointly, I guess gives you more safeguard, because it means that all the attorneys have to sign for everything, but it does become a bit unwieldy for perhaps smaller matters that all the attorneys have to sign for every single last thing or every single kind of banking decision. But having said that, jointly it means that if you've got two, if you've appointed your spouse as an attorney, perhaps with one other child, if you've got two, if something happens to one attorney, and it's on a jointly basis, it means you have a useless document, because both attorneys would have to sign, and obviously one of the attorneys can't sign for that. So, generally jointly and severally is probably the way to go on a practical level, which means that only one attorney has to sign for anything. So it's probably better on a practical level. Jointly, perhaps for bigger decisions around selling the property, or where you want to receive care, whether it's at home or perhaps into a care home of choice, and those kinds of things. Important that these things are deliberated anyway. It's just not a case of just ticking a box and hoping for the best. You need to make sure that decisions are being made in line with your wishes. In terms of replacements, I would probably consider not having replacements. A lot of people will say they want your spouse as an attorney, and then perhaps having replacements being the children to step in if that was required. Unfortunately, on a practical level, it doesn't cater for a couple of things. So what happens in temporary arrangements? So what happens if your attorney is not able to deal with things on a temporary basis? So they've perhaps had a fall themselves and they're in hospital, or they're on holiday, or for whatever reason they can't act on a temporary basis. It doesn't cater for that, because it does take, in some instances, months for the Office of Public Guardian to get those replacements into role, and they might ask for additional information as to why the replacements are being nominated. So at a time when you need those replacements, there might be a delay where effectively all decisions and things are on hold. So it doesn't cater for temporary arrangements. Also doesn't cater for the fact that there is that delay. So what happens if your attorney dies or passes away? So you need someone to come in immediately in those instances, and if there is a delay, that's not good on a practical day-to-day level to get things moving. So tend to veer towards listing all the attorneys on the official document, and then alongside that have either preferences and wishes used on the actual legal deed to let or give guidance to the attorneys about when to act, who's to act, in which circumstances, or have a side letter of wishes where you can give guidance to the attorneys, as again, how to act, when to act, who's to act in certain circumstances, who to act in other circumstances. So, and that applies to the different roles within the lasting power of attorney. So if you feel that your son is the best at finances, and your daughter might be best at the health and their caregiving, you could have that laid out clearly in the lasting power of attorney document itself, to ensure that the right people are doing the right jobs. Or alternatively, and what we tend to do in practice is that we'll go through a letter of wishes with you, preferably in your writing, where those sorts of things can be kind of detailed out for the attorneys. The reason why I tend to prefer letter of wishes is because it's flexible and things change over time, and they form part of our financial planning reviews. So it just enables you to kind of change your mind basically over time, you know, because the actual lasting power of attorney document is a legal deed that can't be changed. It's not to say that you can't have preferences and wishes and guidelines within the deed. It just, if we do go down that route, we need to make sure that everything is clear and correct and legally enforceable during the application stage. So there's definitely things to think about with those sorts of things. Things to discuss with us when you come in to take your advice around lasting power of attorney. In terms of the certificate provider, so when you're looking at the application for your lasting power of attorney, you will see what's called a certificate provider. Now, this isn't, it's best that we don't think of this as a person, Bob next door or John from golf club, to sign and put the address, witness, and just get it sent off. It's an important legal role, the certificate provider. The certificate provider is the person that is legally presenting the fact that you are knowing what you're doing, you are of sufficient capacity to, and you know what a lasting power of attorney is. You know that by taking this out means that you're giving control and decision making to another person. So really important from outset to know that the certificate provider has a important legal role in that process. It's the certificate provider who plays a significant role when the lasting power of attorney gets registered and actually in use. So if there's any problems, any safeguarding issues, any potential worries about actions about the attorney and these kinds of things, it's the certificate provider who will act as the point of contact, probably the professional that will go to the Office of Public Guardian to explore these kinds of things, looking into disputes. So obviously, you know, when we're advising on lasting power of attorney, we would be that professional, that certificate provider. So we take on all of that legal role. So it's just a word of warning that not to kind of just get, it's probably even worse to have a friend or a family member involved as certificate provider, because it can be a legally onerous role if things perhaps don't pan out how you want them to be in the future. So just something to bear in mind. Kind of on the join the dots theme, from an investment planning point of view, some of you will have ISAs, pension decisions, investments. A lot of you might have financial advisors for that, or fund managers or portfolio managers that are running your investment portfolios. Now, really important that, and again, as financial advisors and legal advisors, we're in a great position here. So as part of the lasting power of attorney document, we would include a clause within the actual legal deed to ensure that your relationship, and then in time the attorney's relationship, continues with your investment provider or your portfolio manager or your advisor or whoever you use for your financial planning. And that's really important, because if that's not there, and different financial institutions have different opinions on this, that relationship can trip up at the point that you've lost capacity and the LPA is in force. So that could mean that the attorney is effectively hamstrung when they look to continue that investment relationship. So as a cautionary clause within the document, we would always put this clause into the lasting power of attorney application to ensure that relationship can continue, you know, for the attorney, you know, going forward. In terms of the actual choice about whether to register the lasting power of attorney or not, I would always recommend to register the lasting power of attorney application immediately. There are downsides to that on a safeguarding point of view, and we'll come to that in a moment, but in practical terms, it's by far and away the best thing to get these documents registered immediately. You know, we see documents at the application stage, but they're not registered. The reason being that there's this delay to get your LPA registered. And if it's not registered at the point that it's needed, that can cause stress and delay and effectively putting all decisions on hold until the registration happens. So definitely just get them registered so they're ready to go when the time comes. And also from a temporary point of view, similar to what we were saying before, there might be instances where the lasting power of attorney is needed on a temporary basis. So for instance, if you're on holiday or on that world cruise, or perhaps you've had an accident and you're in hospital for a short period of time, it's sometimes useful just to have that attorney step in for 6 weeks. It's all registered, all ready to go, and just kind of look after your life in those few weeks that you can't handle things. So even on a temporary basis, in this harsh weather, this kind of heat waves we've been having, sometimes it's just not easy for you to get out or not safe to get out. Sometimes it's useful for your attorney just to pick up that medication, go down the bank, all these kinds of things, quite useful from a practical point of view. And the final thing I wanted to say about the actual application stage is the health and welfare lasting power of attorney can only be used when that person's lost capacity, when the donor has lost capacity, as opposed to the finance and property one that can be used ongoing once registered. The health and welfare one, it's important to know, that can only be used once you've lost capacity. Now, the reason why I mention that is because it makes it even more important that that when you're actually applying for your lasting power of attorney, that we get everything right and all your preferences, all your wishes, everything, all the guidelines right from outset, right from the application stage. This is your chance to get all your wishes in line, get them communicated to your attorneys when you have full capacity to do so. Because if they don't have any of this conversation or wishes or preferences, and you've lost capacity, basically then the attorneys are left in a position where they're acting for you without really knowing what your preferences are. So lean on us to talk about the things that might go into the preferences and guidance section of the lasting power of attorney. Make sure they're enforceable, they're in line with living wills and advanced decisions, and make sure they're practical. Most of the guidelines are around care fee planning and care funding and living arrangements, like where do you want to receive the care? Is it at St Monica's down the road, or is that where you want to be, or is your preference to stay at home at all costs? All of these sorts of things can be properly documented on your lasting power of attorney up front. Again, it's not a case of just getting some names and addresses, getting it submitted. The whole point of these documents is to make sure that they're available and they're giving guidance to those attorneys when the time comes. As a natural point of our review process, again, what shouldn't happen is that you get these forms signed and they're left in a top drawer and they're forgotten about for 10 years, and then suddenly they're needed by your attorneys and they've got literally no idea what they're for, basically. We want to get away from that. So as part of our review process, we will review your lasting power of attorney along with all your financial planning documents to ensure they're fully up to date. We will lean on the letter of wishes on a minimum of a 3-year basis to ensure that your wishes and your preferences are up to date about what you want to happen. Specifically around financial planning, we can kind of look at your care fee funding and how best to kind of pay for the care, going forward. So that's the end of the application part of the talk. That did kind of trigger some questions and things like that. If we go back to absolute basics, there's 2 lasting power of attorney documents. There's one for finance and property, one for health and welfare, for 2 different documents. You need both are important. And when you apply for the documents with the OPG, there's different departments and different case managers that register and process different documents. So your finance and property will be dealt with someone in a different department to your health and welfare. And in my experience, they deal with things differently. So different mistakes are dealt with differently. And so we want to make sure that application process is correct. For a small investment in some advice, if it was me, I would take advice during this initial stage, because we know that there can be problems down the line if these legal documents, one, are done correctly from an admin point of view, but two, are looking at the overall picture and making sure that from a bigger picture point of view that all of your financial plans and your legal plans are joined up and are basically in a good place and ready to go when the time comes. So that's the end of the application process. Leave your comments. If you've got any questions, let me know and I'll get back to you. So now we move on to specifically the finance and property lasting power of attorney. And I call it this in-between stage where I'm still dealing with a donor, I'm still dealing with a person that's taken out the lasting power of attorney. They're still the client. I mean, they'll always be the client. We will always be dealing with you as the client, and we're dealing in your best interests. But at this stage, everything's going really well. You're living your life. You're living in retirement, hopefully well and healthily. But the lasting power of attorney is registered. So this is a kind of a grey area. And I would strongly, again, argue and recommend that there is some sort of independent professional advice process during this process. I'll tell you why. So there's a big push to get everything online. I'm sure you have seen, everything seems to be online, doesn't it? AI and Zoom, and you're watching this on YouTube, and and to a degree, I agree with the speed and perhaps the accessibility of being able to apply for things online easier. The reason being is because, like I said, the amount of people that have lasting power of attorney is so low, a lot lower than you would think, and I think it's something like 60 or 70% of over 65s don't have a lasting power of attorney. So I agree that it's better to have a lasting power of attorney is better than not having any at all. So from a point of view of an accessibility for the general population, I agree that it's better to actually get things done if you can. But our typical client is someone that's sophisticated financially, that they've got investment plans, they might have inheritance tax worries, they've got decisions around care funding to be made, they might have pensions and pension decisions and self-invested pension plans, and all of these things that financial planners that are dealing with on a day-to-day basis. And for those kind of clients, they might have property portfolios and decisions to be made around property and these kinds of things. For these types of clients, it's not appropriate just to submit things online in the cheapest way possible and think that things are being handled in that way. It's much more appropriate for people that take financial advice to have a much more joined up approach and take advice across all of your matters, including financial, legal, and by the way, all of your kind of later life concerns. So partly from an expertise point of view, to give you that extra safeguarding and advice around the whole process, but also I'm very concerned. I'm an old school financial planner, legal planner. I like everything face to face. I believe everything should be deliberated, ongoing, face to face, lots of face to face meetings. In my opinion, that's the only way that you can give advice. Once you know the financial dynamics, you feel the energy of the family and you as a client, only then can you really give proper advice. And unfortunately, that could be potentially be circumvented by a more online way of doing things. So I'll let you know the process. So if you apply for a lasting power of attorney, your nominated attorneys will be emailed or a notification to say that they're the attorney, that they can start acting. And remember, these attorneys might not have any idea what a lasting power of attorney is or what it means. And the danger is that attorneys at that stage feel that they should be doing something, perhaps, because they've been, they've been nominated as an attorney, they've been told that they can act as an attorney, and that to me has safeguarding issues. A lot of it is because people think they need to be doing, or they might decide what's best for mum and dad without really knowing the legalities of how a lasting power of attorney should be enforced or enacted. They might start doing things that they feel that might be in the best interests of mum and dad, but might not necessarily be in their best interests, or it might not fit in with the will or other financial planning that's going on. And so this whole process might happen without any kind of professional advice or safeguarding involved at all, and that's where kind of problems can happen. And disputes and fallouts and all these kinds of things. So what should happen, and what happens with us when you're dealing with us through this process, is that once the lasting power of attorney is registered, that's absolutely fine, but you'll still be our client as the donor. You'll be coming in for your financial reviews annually. And at that time, that's where our financial planning hat really comes to life. So we will be dealing with all your inheritance tax planning, we'll be dealing with all your care funding decisions, and we'll be dealing with investments and pensions. So this is the golden time where we really want you to take proactive financial planning advice, so that everything is organised, hopefully that you don't have inheritance tax to pay, and all of these kinds of financial planning things are done at this time. And in addition to that, and if you're happy to do so, we will get the family involved as part of that process, so that the attorneys are fully up to speed about your financial planning arrangements, about how things are being managed, about your ethics, about your goals, about your risk profile, about not even just a financial planning point of view, but from a health and living arrangements, and about all the kinds of things that you want to happen, if and when the time comes. So we'll be detailing out these things on a letter of wishes, along with your financial planning review. So all of this is the planning, the proactive planning, which obviously as financial planners we do on a day-to-day basis. And so we're getting away from this situation where your LPA gets done by a solicitor or by yourself and just gets forgotten about for years and years and years and years. And there's absolutely no planning or advice done after registering the lasting power of attorney. So really important, this is a living document, a living part of your financial planning. A small piece of investment now can really bring rewards down the line as part of your overall process. So this is that kind of golden time. The other big thing that I get asked, and we had a conversation about this at some of our live events, was that as donor, as the person that's taken out the lasting power of attorney, you will always be our client. And this is something that's probably misunderstood by your attorneys. I mean, why would they? Because they haven't got a back history in legal training. At every point of your life, you will always be the client, and we need to do everything to ensure that you're still making the decisions. Even if you're having issues, even if you're having memory issues, even if you're being diagnosed with illnesses, or you're aging, or you're just having difficulties on a day-to-day basis, always you should be the client until the absolute last possible moment that you can't make decisions. So even if we're having pressure from family members, that you're still the client. So that provides a great safeguarding process for you as the person that's taken out the lasting power of attorney. So what does that mean with us as an advice firm? So it means that we will do everything to accommodate you as our client going forward. So we'll have shorter meetings, we'll have different meetings on different times of the day, we will address different decisions at different times. Depending on what your concerns or issues are, we will do our best to accommodate those. So what I'm trying to get across is that capacity, it's all about decisions and different types of decisions, different times that you're making decisions, and we need to accommodate you as the client, as the person that's still making those decisions, if you want to. So it's not about unwise decisions. You're allowed to do things that you want to do, decisions that you want to make. So we get a lot of families that are kind of think they know what's best for mum and dad, but we have to respect you as the person that's making those decisions. And as I said, until the absolute last possible moment, you should be the client. But we'll safeguard the attorneys as well. So in most instances, the attorneys are the people that want to do best for mum and dad, but suddenly they've been given this responsibility that in their eyes. They don't know what capacity is. They don't know, they're not financial advisors. They're not legal planners. They don't know what the history of mum and dad's finances and what their actual preferences are about how they want their life to go. So we will work with those attorneys if possible, and if the donor wants us to, ongoing. So the attorneys will be fully briefed and understanding with mum and dad about what's going to happen if and when the time comes. So we just want to get away from expensive, crisis-ridden, stressful times where we're dealing with these sorts of things at a point of crisis. We want to get all of these things set up correctly, properly aligned with your financial plans during this, as I say, golden time. So we want all your inheritance tax planning to be aligned with your will planning. We want the lasting power of attorney to be aligned with your care fee planning and your investments. We want your pension planning to be in line with what you want to happen in terms of intergenerational and passing money to the children and grandchildren. It's all related. So I think that's probably the crux of our unique proposal that I'm talking about today. Is we're bringing everything together at a time when we can do. We're taking control of these things at a time when we need to be doing so. And probably one of the biggest, if not the most important role that we have, is opening up these conversations, getting people talking about the importance of not only getting these documents in place as one thing, correctly and legally, but also having them all connected to your financial plans, getting the family involved, and so that when the time comes, it's the most stress-free process that you can get, and that even when the time comes and you can't deal with your own affairs, that all of your wishes and all of your goals just seamlessly continue because you've had that opportunity to guide those things at a time when you were able to. And know that we are here to support you and the family and your attorneys at that time. So that's the end of that that in-between stage, I would say, where the financial and property one has been registered. The attorneys are kind of dealing with, or not dealing with things, but they're sitting in the background as a registered attorney. We're dealing with things with you as the client, hopefully getting everything organised. I mean, obviously, inheritance tax is our ultimate speciality, which we do on a day-to-day basis. We want to eliminate that during this phase so that we don't have to rely on other things, once you've lost capacity. So just trying to think of other questions that were asked. Specifically with capacity, a question was like, how do you decide on capacity and when the time comes? Obviously, this is very individual specific. Usually we've won awards around vulnerability, and we're highly trained at dealing with people in retirement and later life. It's the whole point of our face-to-face offering. So for a good amount of time, we will be able to assess, and all our written notes and file notes will be able to safeguard you as having capacity and dealing with that. But obviously we're not doctors, so if it reaches the stage where we're starting to have doubts, at that point we will engage some of our signposted professionals. We have a mental capacity assessor who actually his only job is to assess capacity around certain decisions. And that's important to protect and safeguard not only you as the donor making decisions, to make sure that any decisions you make can't be challenged or disputed, but it also gives practical safeguarding and protection for you as the attorney when you're making decisions, to make sure that, you know, in the eyes of the rest of the family, you're doing absolutely the right thing, you're taking advice from us, from medical professionals, that you're doing the right thing in the eyes of the law, you're doing the best interest for your often mum and dad in those instances. So just don't go on this alone. And it is a difficult circumstance, you know, it's a stressful time, you know, mum and dad's, you know, getting older, they're starting to have issues. I would strongly recommend that you take advice and guidance, you know, from us and other professionals during that kind of process. So if anyone's got any further questions around that section, around that kind of in-between phase, just leave comments or questions below, and I'll get back to you. Now let's move on to the section, pretty much the final section, I guess, from a lasting power of attorney point of view, where you now are having such issues you're not able to deal with your affairs anymore, and that's now when the benefit of having that lasting power of attorney comes in. Now the lasting power of attorney is in place, now your attorneys take over. So on the health and welfare, obviously this is the only time it can be used because you've lost capacity. Some people say that, you know, how or when is a health and welfare document needed? Doesn't the doctor just deal with my spouse? That is true to a certain degree. So in an emergency, or if you're in hospital, the doctor's probably likely to look to the spouse for guidance and advice and tell them what's happening. Where the health and welfare one really comes in is to give guidance and preference about what you want to happen in all these different circumstances, even down to life-sustaining treatment. And if the family don't agree or argue or dispute about what's best for mum and dad, this is where the problem happens, and then it can end up in court because no one can decide what's best for mum and dad. Some family members might have decide on this, or some family members might think that. They just can't agree on things. So this is the importance of getting everything laid out in advance, about all your wishes and preferences about what you want to happen, you know, when the time comes. So there's just no debate from the attorneys. It all kind of happens because you don't want those disputes. Can end up in big legal fees, legal bills and delays and stress just at the worst time. In terms of the joined up advice around investments, like I said, our investment clients will be fully briefed at this stage. You'll have had regular financial planning reviews. We will know you as attorneys usually. At the absolute minimum, you know, you as the attorney will know us, having that relationship with mum and dad, even if you don't know the details. Ideally you do know everything, but if in some families you want that privacy, you'll be directed to us at that point. Often we can kind of continue things. This is the stage where you don't want the attorney kind of just doing different things and organising different things, investing in different things without any proper professional advice or guidance, and also having a view of the overall picture. So you don't want to the attorney to say sell 50,000 of premium bonds and invest somewhere else if in the will the premium bonds have been left specifically to a certain beneficiary, just as an example. It all needs to be joined up. Strongly recommend that your attorneys take professional financial advice, mainly for their own protection, to do what's right by the donor, because you have to be working in the best interests of the donor. And in the eyes of the rest of the family, it's best to get that professionally done. And also often the case, we're dealing with the attorney, at that point the donor is not able to deal with their own affairs, and then it often triggers a reset of your financial planning. The way what I mean by that is, if you've got into a care home, the investments and things like that you originally set up might not now apply, because you might need to be investing somewhere else. You might be looking at care fee funding. You might have the property decisions or sold. So it often means there's a reset in your financial investment planning at that time. So it naturally triggers a meeting with us anyway, with the attorneys, to ensure that the attorneys are taking full, proper professional advice around all the decision making around those decisions at that time. So it might mean that there's a change of direction anyway, to make sure that everything is being done in your best interest, in terms of the donor's best interest. So once you've taken over someone's affairs, strongly recommend that you take financial planning advice at that stage. Obviously, if you've been through the whole process with us, it's a seamless process. If you're coming into it from I'm suddenly the attorney for mum, I don't know what to do, or I'm not sure what I'm doing, at that point, still fine to come to us and we can give you advice from a financial planning point of view. Inheritance tax, hopefully, as I said, you've joined us from a previous stage, and there might be no inheritance tax now. If the donor has got inheritance tax liabilities, and you now as an attorney are keen to reduce that inheritance tax, both for the family and both for yourselves, it's really important that we have established a strong pattern of behaviour and guidance before that we reach this stage, because you are very restricted about the amount of inheritance tax planning you can do as an attorney. So I would urge you to kind of go back to the previous stage and start working with us and establishing a process and a written guidance and advice around how to get the file in place to continue that inheritance tax planning. Gifting is very restricted as an attorney. You can only gift on birthdays, Christmases, that kind of thing. So any gifting or any inheritance tax planning at all really would have to go through the court at this stage, at the stage of the attorney dealing with things. And in order to make that inheritance tax planning as successful or effective as possible, the courts are going to need evidence that it's in the best interests of you as the donor that you wanted to make inheritance tax planning, or you really want to do inheritance tax planning. So that, from a practical point of view, that might be gifting to the grandchildren, say, either outright or in a trust, to bring forward perhaps that gift from the will. So bring forward the beneficiaries from the will. So again, it's that joined up thinking. So if you were going to give a certain amount of money or assets to the grandchildren in the will, it could be the case that we can get that kind of that planning done in lifetime, after you've lost capacity through the attorneys, if that's all been written out and set out before. Any gift work or any inheritance tax planning, we need to have that evidence in letters of wishes or patterns of behaviour in terms of your financial planning reports before you've lost capacity. So we do have to kind of go a stage back, but then we'll work with your attorneys to put together, probably with a solicitor in this case, to the courts to get that inheritance tax planning ordered through the court. It might be, for those interested in inheritance tax planning, it might be that you've got assets over a 2 million threshold or the 1 million threshold. These are important thresholds for inheritance tax purposes. So we can get those gifts done or that inheritance tax planning done to get you under those thresholds to really reduce the amount of inheritance tax to pay for you as the ultimate beneficiaries, I guess. But the only way we can do that, I'm repeating myself, is to get the file and the guidance done before you've lost the capacity. So then we can work with the attorneys to get that efficient inheritance tax planning done. And probably the most important stage really in our practical experience is the care fee planning. So we will at 99.9% of the time be dealing with the attorney when mum and dad have lost capacity, they're in a care home, and suddenly the attorneys is having to make big decisions around financial planning, how the care fees are going to be paid for, what we're going to do with the property, what we're going to do with the proceeds of the property. And here it's vital that you take financial planning advice, because this is a very complex niche and specialist area, and there's products and arrangements that are only actually available through specialist advisors, which I'd urge you to engage with us on. So for instance, the one that's least known about really is the immediate care plan, where you put a lump sum into an arrangement, and that will pay a guaranteed income tax-free for life to a care provider, whether that's at home or in a care home. And that has tremendous tax advantages for inheritance tax, for income tax, reduces your estate immediately for inheritance tax, paid out in income tax free, as I said, if it's paid out to a care provider, puts a cap on the cost of care, because a lot of attorneys and families are worried that mum and dad's assets are all going to go in care costs. So really important that we're putting a cap on the cost of care by effectively taking out an immediate care plan. Definitely worth thinking about, getting quotes, talking about a part of your own financial planning strategy. We've got investments, cash savings, all these different things as part of how care funding can be paid for. So if you are in that situation and you're coming in late into the process, and basically it's a point of crisis, you know, mum and dad's gone into a care home and you need advice around lasting power of attorney as an attorney, come to us at that stage, because we can still help, you know, at that stage of the process. So that's the stage where, that's the end of my talk around where you're actually acting as an attorney for mum and dad. As I said, ideally, we've been through all the different stages, and that's quite a seamless process, because we know you as an attorney, and we know mum and dad's guidance and wishes and investments and everything like that. So in our world, that's quite a seamless process. In the real world, we get a lot of clients coming to us at that stage, because it basically is a moment of crisis. People have had a fall, or they've gone into a care home, or mum and dad just can't deal with their affairs anymore, and the attorney suddenly is thrust into this position where they're suddenly dealing with legal matters, financial planning matters, and you know, they're just not equipped from an expertise point of view to make these decisions, and they're worried, not only because they want to do their best for mum and dad, but they're worried that in the eyes of other family members, are they doing the right thing? So come to us, lean on us, even if it's just an initial chat, initial meeting to talk us through your situation. You know, we have 100% record of at least making you feel better after you leave that initial meeting, even if we signpost you to the right people. But often we can help, because you know, this is our specialism, this is what we do on a day-to-day basis. That's the end of that section. If you've got any questions or comments around that, just let me know on the comments section, and I can kind of let you get back to you on that. Or if you'd rather not just leave messages online, just give us a call and we'll kind of talk things through with you. Or alternatively, as I said, just come in for that initial complimentary chat with us, very relaxed, where we can kind of take you through some of our guidance and what we would advise you to do at that stage. That's the end of the lasting power of attorney section of the talk. It's quite a lengthy one, I know. So if you're still with me, let's talk about wills and probate. 60% of wills, 60% of people in the UK don't have a will in place, which is, again, a startling statistic. I just think people just don't want to think about these things, perhaps. It is a really important part of the estate planning process. Obviously, you're deciding about what, where, and how your assets are going to be managed and dealt with after you've passed away. But the will, again, is only a part of your estate planning process. You need to be thinking about your inheritance tax. You need to be thinking about what you want to do with your assets. In fact, as part of the will process, and part of the process to make a will legally valid is you have to know and list out the assets that you actually have. Be aware and completely understand what your assets are and what impact and who the likely beneficiaries or who the expected beneficiaries would be in your instance. So all of these are part of that process, and obviously as financial advisors, that gives us the opportunity to recommend different things with these assets, especially if it's inheritance tax, which is your most important priority. It might not be, it might be care funding, it might be investments, it might be pensions, but uniquely during that will writing process, we can give you advice from a financial planning point of view as well. I've been in meetings with will writers and solicitors who only deal with the will, and it's basically any other financial planning is left, including inheritance tax planning, and that's the advantage of having that joined up thinking during that process. It's very similar really to the lasting power of attorney applications that I would strongly advise that you take advice even from an admin point of view when you're doing your will. It's very easy to invalidate a will. You can make mistakes, you can sign in the wrong place, you can not go through the legal process of getting everything witnessed and done from a very legal point of view. The attestation is quite a solemn legal process, the attestation meeting that we have with clients. Certain people can't be at certain times, and all of these kinds of things need kind of making sure that it's legally valid, making sure that it's properly witnessed, that a proper legal process has been managed. Again, just to give you the peace of mind that at least your will is valid. I mean, one of the biggest growing legal advice roles in the legal world is disputed wills, contested wills, beneficiaries making claims against wills, all of this kind of thing. You can Google any solicitor firm, medium, lit, large firm, and you'll see the number of solicitors that are dealing with contested wills, problems, disputes, and the number of solicitors that are actually dealing with making a wills is very few in comparison. So it's all about getting that application, the will writing done up front. So to spend that bit of legal money, a little bit legal advice up front to get these things right can ensure that everything is done properly and your hard-earned assets and investments and everything like that is catered for, when you pass away in the future, with a view to having all your financial planning goals fulfilled as well when the time comes. So just make sure you get a will, is probably the first thing. It's better than not having a will. If you don't have a will, you're basically subject to the rules of intestacy, where the government decide where your assets are going to go, and that might not necessarily be where you wanted your assets to go. So definitely get a will, definitely take some advice through that legal process. There might be things that you haven't thought about. You don't know what you don't know. So we need to take into account those what if situations. What if your beneficiary passes away before you? What about blended families? What about divorces? What about kind of life as it goes on? Things like gifts and charitable gifting. Your executor is a really important decision about who you want to deal with those affairs. Again, people nominate a family member to be executor, and that's almost seen as an honour when you first get nominated. But then the time comes and then you're suddenly an executor. Suddenly you have to be a legal professional at the most stressful time. Potentially you're dealing with quite sophisticated things around inheritance tax and different kinds of things, legal process, around also the stress around following all these different processes that you have to do, the administration involved. It can be quite a burdensome role. So I would always recommend anyway to use a professional like ourselves as an executor, or an absolute minimum. Again, have us involved or to lean on and to advise the executor when the time comes. Again, the ideal situation is that we've known you through all of these years and your executor is well known to us. So when the time comes, when you've passed away, you know, we can either advise you as executor or attorney, or we can take over the whole thing. It's just entirely up to you. But don't struggle alone. You know, there's unlimited legal liability as an executor. It's very easy to kind of get things wrong. We have, as I said, we get beneficiary disputes and claims, and it's very easy to make mistakes. Inheritance tax is the big one. I'll come on to probate in a second about how complex that is and about to get even more complex going forward. So definitely get a will done. Many people just think a mirror will suffice, and it sometimes can. A mirror will is where everything passes to the surviving spouse, and then everything passes to the children on second death, which is a simple and cheap way of doing it. Again, if you have sophisticated assets, inheritance tax issues particularly, or certain issues that you might, which we'll take you through when you come in to talk to us about your will. Specifically, some people are concerned about care fee costs and how that can really ravish through your family's assets. The reason being that if it's a simple mirror will, the surviving spouse has all of the assets, including all of the house, and that means that all of the assets then could be subject to care costs. So if you're concerned about that, let us know. Some people are concerned because there's a lot of trust involved with a will, a mirror will, because first person's to die, the surviving spouse could effectively just change the will the very next day, either just because they want to, or because they meet someone else and remarry, or they might join up with another blended family, or there might be divorces amongst children, or anything can happen really. Life can happen in the future. And so there's no guarantee that the person that's died, that their wishes are fulfilled under a mirror will. So the way round that, for that and for care fees actually, is to create a trust on first death, where half the property, half the assets drop into trust on first death, with the beneficiaries being the people that you've chosen to be the beneficiaries. You know, it's often the children. And what that does is ring fences and protects those assets for the person that's passed away's children. Guarantees the assets go to them. It means that the surviving spouse can still live in the property. They can still take an income from those assets. It just means that the capital is protected for the children of the first to die. And that can give people peace of mind, protected from care costs if the surviving spouse had to go into care, all of these kinds of things. So we'll take you through some of these scenarios when you come in to see us, and we can decide whether these are important enough issues for you to put together a protection, added protection within the will. Again, quite a small legal investment can mean, in some cases, hundreds of thousands of pounds worth saved, you know, down the line, and protecting your wishes, you know, after you've passed away. So that's a brief run through of wills. If you've got any questions around wills, any comments, or got questions about how things work, or perhaps if some of these things you've been thinking about, like the care costs potentially, or inheritance tax, either leave questions or comments below, or just give us a call and then come in for a meeting. We can chat about those things. Just finally wanted to touch on probate. We did talk about that briefly in terms of the executor. So it's the executor's role to deal with your estate after you've passed away. Hopefully that person is the person that's been through all of the steps of the process with us. So they've been the attorney, they've been the person that we've been dealing with anyway through those different stages. But even if you've just suddenly been thrust into the role of executor and you're really not sure what to do, definitely come in and we can help you even from that stage onwards as best we can. Similar theme really. A lot of the problems are around admin, about not getting the right forms, not following the legal process properly, delaying filing forms and letters, and especially dealing with inheritance tax is a big issue because it can get very complicated. Again, hopefully we've solved the inheritance tax a couple of stages before. Ideally, we've dealt with your estates before you've passed away, so we've got everything organised, we know everything, where everything is, we've consolidated things. The executors have a very simple idea about where things are with our help. We don't want to land the executors with a very complicated decision, because again, that's where the expensive solicitor fees come in down the line, because everything needs to be organised down the line when you're not around to help us. So it's all about preparation, planning, getting all things simple and organised for when the time comes, and then leaning on us at that time, leaning on us as professional help, and letting you deal with the kind of the emotional crisis side of things. We have signposted professionals that can help in that area as well. But from a financial point of view, a legal point of view, just letting us either help you or let us do the whole thing and take it all off your hands. A final word on probate, because it's so topical and it's so relevant to this Join the Dots talk today, is that from April next year, 2027, pensions will form part of your estate for inheritance tax purposes. And it's just going to make the whole probate process even more complex than it even was. So the way I gather it, and the processes are still being worked out by the authorities, is that there's going to be a parallel running of your probate process with what's called the free estate, which is your properties and your assets and your investments, bank accounts, all those sorts of things. And then you're going to have a pension process, because pensions previously haven't been part of your estate. Now they're going to be part of your estate. So there's a pension process whereby your assets, your pensions are going to have to be organised on a separate process. Where the issue is going to be is where you've got inheritance tax on pensions and on your free estate. So we've just come to an end of a consultation within our industry that we were kind of looking into, and there's been a lot of pressure put on the government to extend the time frame by way inheritance tax is going to have to be paid. It's currently 6 months, and the result of the consultation was that it's going to be an impossibility, they say, is on the consultation, that that people dealing with estates, including professionals, are going to be able to pull everything together within the 6 month time frame in order to be able to pay the inheritance tax after 6 months. So we've been campaigning to get this deadline out to 12 months. It's unfortunately it's still 6 months, and as we know, any unpaid inheritance tax is going to have to be paid on a quite punitive interest rate if it's not paid within the 6 months. So it's going to get much more complex. In terms of the decisions, we need to make sure where the inheritance is going to be paid from, whether it's going to be paid from the beneficiaries or the executors, or whether it's going to be paid from the pensions or the free estate, whether we're going to apply nil rate bans to different pensions, or free estate and the nil rate pension, how that's going to interact with the main residence nil rate band. It's going to be quite a complex area. You know, solicitors are not going to be well versed, and they're not going to be familiar with pensions as this secondary process. So it puts us as financial and legal planners who only deal things from a bigger picture point of view in a very strong position to help you with this process when the time comes. So yeah, just know that if anyone's going to be able to help you at this stage, it's going to be us. Practical steps that you can take before, if you are worried about this, if you have any unused pensions and you're worried about inheritance tax, either come along to the inheritance tax we'll probably be doing later in the year, or look at my video recording that I've previously done on that topic. Come and see us to take advice on that. As the absolute minimum, look at kind of consolidating any pensions, because that will really help your executors when the time comes to organise your affairs during the probate process. Just be aware that it's on the horizon and start having those conversations now with the family, with us, to make sure that everything is simplified and consolidated, and that we're addressing the inheritance tax now, really, because often when it gets to the probate time, it's all about just getting things right from a legal point of view. It's almost kind of the horse is bolted, so get everything planned well in advance. So if you are in that golden phase where I'm still dealing with you as a client, and you're thinking about taking lasting power of attorney out, that's the golden time to start talking to us and getting advice, getting things simple, getting things planned in advance. But at any stage, you can join us, and we can kind of start giving you advice at that moment, whether you're the donor or the attorney. We do have a unique perspective, as I said, as financial and legal planners. Not only do we have that unique specialism across financial and legal, but we only specialise in people in later life, retirement and later life. And our whole business has been set up for this purpose. And not only that, we've got specialist professionals and charities. We do a lot of work in the local community for later life. So lean on us if you need help and support in this area, even if it's down to guiding you towards Welcome Wednesdays once a month, or the Fab Cafe that I do at St. Peter's. Whatever it is, we can guide you, even in a small way, to help you going forward. I'm a big believer, as you probably imagined, in face-to-face advice. I believe that people like you that have sophisticated needs, that you really want us to understand the family dynamics, that can only be done face-to-face and over time, at times that suit you, and then we can really work our support and advice around you and the family properly. Definitely, if these sorts of things are of interest, or you're concerned about anything, or if you are in retirement or later life and you haven't properly, or perhaps haven't in a deep way thought about these sorts of things, just get in touch, give us a call, and we can hopefully help. There's a complimentary meeting, as I said, in the office if you're local. We're in northwest Bristol, but we deal with clients locally, I would say, probably 15-20 minutes. Thornbury, we get clients from these different towns, but predominantly northwest Bristol. If you want face-to-face advice, I would say, but just give us a call if you have any questions. So that's kind of the end of my talk today about estate planning, join the dots. I hope it's been useful to you. It's been very useful to me to kind of run through things again. If you do have any questions and you're not comfortable contacting us, just kind of leave them in the comments below, and I will help you. We help people with care planning and inheritance tax planning, so I'll be doing future videos and events later in the year. But that's the end of our estate planning Join the Dots workshop today. So thanks for joining, if you've been with me to the end of today's video, and we'll see you again soon. Okay, thanks again for joining. Thank you, bye.